This honorable court is back in session. Please be seated and come to order.
All right, good morning. We have our third and final case this morning. Barry Farm Tenants and Allies Association versus DC Zoning Commission.
Hi, my name is Aristole Theresa. I'm the attorney for the Barry Farm Tenants and Allies Association, which will be referred to as BFTAA. I'd like to reserve 3 minutes of my time for rebuttal.
All right, thank you.
May it please the court. Today we're going to talk about primarily 4 issues. The first one is that the Zoning Commission erred when it found that the URA governed the relocation process, and since the URA governed the relocation process, that Policy 2.3.1 was outside of its jurisdiction. Policy 2.3.1 is a comprehensive plan policy which provides for the avoidance of dislocation and hardship at the Barry Farm site. 2, they erred when they found that even if they did have jurisdiction to consider the relocation process, that Policy 2.3.1 was followed by the developers because they took steps to avoid hardship. This was an error because it it did not use or interpret the "or" in the statute correctly. Young v. U-Haul is informative as regards that. 3, they erred when they found that open space was a benefit. They found in their order 78A that the introduction of public outdoor amenities of various types, scales, and levels of privacy was an actual benefit when currently there's much more open space and there are varying levels of privacy, and it's actually a detriment to the project that residents will lose open space. And 4, they erred when they found that the project could go from they didn't err, but they abused their discretion when they found that they could go from 1,100 units to 1,400 units on a smaller footprint without any evidence which would necessitate such a change.
All right. We have the Commission's original decision in the record where the Commission at least purports to do analysis on each of those issues. And I understand that you have disagreement with how they analyzed the evidence that was in the record. So if I could take them one at a time. I think you first started with the relocation issue that's
Yes.
embodied in policy FSS 231.
Yes.
Now you have an interesting or different reading of that provision than the appellees do. Can you walk me through how you're reading the language of that to show your contention that it was not complied with?
Okay. Well, it says that the developer should take steps. That the zoning commission will encourage development at the site, which takes steps to avoid dislocation or hardship. Right.
And I think if I understood your brief, the language of the policy says dislocation or hardship, and your contention is the "or" really means dislocation and hardship. Is that
correct? In Young v. U-Haul, they found that when there are 2 words in Young v. U-Haul, I believe the words were permit and authorize, and they found that the words were so similar that they could not ask the court to make a distinction between the 2 words.
If we step back from how you would want us to interpret the actual language of that provision, is your argument that any relocation would make the zoning request, would not comply with the comprehensive plan? Or is it the manner that the relocation is being undertaken that gives you concern?
It is the manner, not any relocation. We are arguing that the forced removal from one's home is hardship. And so if you're saying that you're going to avoid dislocation or hardship, you cannot say, well, we've avoided dislocation and we're going to help with hardship because, well, you can't say that we're going to allow dislocation and help with hardship, because as soon as you've told someone that they must leave their home, then you then have caused them a hardship.
Can I ask you a terminological question? The policy FSS 2.31 uses the language avoid dislocation. And do you understand that to mean, what all do you understand that to mean? Do you understand that to include the need for temporary accommodations because structures that are currently being lived in need to be taken down? Do you understand it to mean having to move off-site as some of the public housing were going to be? Do you understand it to include all of that? What are you wrapping into? What do you think it should be wrapped into that word dislocation?
We believe that it should be in compliance with the NCI initiative, which was to build first and basically to build first or to develop in place.
But just to be clear, if I am living in a home
Right.
At Berry Farms now, and there's going to be development, so the home I'm in is going to be torn down.
Right.
Are you saying that no matter what, there's going to be some dislocation, and the question is the amount of it, because I can't live in that house anymore, it's going to be torn down? Or do you think dislocation is narrower than that? Or
There's a spectrum. Webster's defines dislocation as the disruption from normal activity. And so, if you're developing the site in phases in a way so you could move people around on the site as it's being developed, that would be minimal disruption. If you build first,
or dislocation,
or minimum disruption.
So I guess the question is, one way of asking the question is, do you think, if this regulation is understood correctly, do you think that there's no way to completely avoid dislocation? Because at a minimum, even if you took a build-first approach, there are structures that people are living in, they're going to be torn down and replaced, so that no matter what, there's going to be some dislocation. And the question is, how much will there be, and you try to avoid it as best you can? Or do you think really that's not what dislocation is meant, and it would have been possible to actually develop this with having no dislocation?
I actually think that in this context, dislocation is a removal from one's community. When they put dislocation in the comprehensive plan, I don't think that they were contemplating, moving someone 200 yards from one unit to another unit. I think they were contemplating moving people out of their neighborhoods.
Let me ask you mentioned the NCI, or the New Communities initiative, and New Communities defines build first, or seems to define build first differently than I understand you arguing. And correct me if I'm wrong, but I thought that under the New Communities initiative, when they say build first, they mean begin building some comparable housing, such as the 100 off-site units that are not on the same footprint but are nearby, so that, and I understand that some of the original Berry Farms residents have been relocated to those initial units that were built first. And if I'm understanding the record, New Communities initiative that has this build first requirement seems to think that that has satisfied the build first. But it sounds like you are envisioning the build first requirement differently. Can you explain what you mean?
We interpret it as build first. If that's going to be offered, and build first in a way, it kind of does prevent dislocation because it's in a similar community. However, it should be offered to everybody, because otherwise what ends up happening is you're splitting apart a community. People who have social networks among each other, they rely on each other for different things, and that is hardship in itself.
Well, the relocation plan, and maybe I'm taking some of the points of your argument out of order. Part of your argument is that the zoning commission, you argue, erred when they didn't feel they had jurisdiction to consider the relocation plan itself. Is that correct?
Yes.
Now, the zoning commission says that they don't have the jurisdiction or the authority under their statute, that the relocation, as you said yourself, is governed by a different statute.
Now, zoning commission did not find that. They said nothing about their own empowering statute. All they spoke about was the URA.
Well, I thought they said they didn't think they had jurisdiction to consider some of the arguments about the relocation plan itself, that it is the URA that governs that.
Yeah, they said that the URA governs, and the URA has a provision in it that calls for the coordination between local governments and the lead dislocating agency, or the lead relocation agency. And it's our reading that they should be allowed to work together and to coordinate this together, and that it's not it's not a hierarchical thing. So it's not that the URA governs this and zoning has no say.
Well, the zoning commission did review the relocation plan that was submitted with the original zoning application by the applicants. And then they also asked for some follow-up relocation plans and regular updates. So I guess to some extent they seem to be exercising some oversight or consideration of the relocation component of the plan. But under your view, they're not going far enough, is that it?
Well, just in the finding of their order, they say outright that it's not in their jurisdiction because it's governed by the URA, and the URA confers no jurisdiction to zoning. And so that, to me, says that whatever they did during the hearing was mere lip service. And when it came to the order, they found that it just wasn't within their jurisdiction.
Can I ask you concretely, what is it you think the zoning commission was required to do with respect to relocation, dislocation, that it did not do? What are the mandatory protections that it just couldn't lawfully omit, that it didn't impose?
Well, I think the zoning commission had a duty to apply policy FSS 2.3.1, and in doing so, they should have accepted the testimony of Brett Williams. Marcy Cohen should have been taken from the panel because she was biased. I think that they should have heard our arguments as far as relocation and dislocation was concerned, and they
that's a little abstract.
Yeah.
That's a little abstract. Is
Okay.
there something like? Do you think it was any plan that moved people off-site and didn't replace one for one was unlawful under this provision, or what are the substantive things that they had to have done if they had been properly giving weight to this aspect of the?
I think if they were going to rely on build first, that it should have been offered to every single resident there. I also think that when it comes to avoiding dislocation, if they weren't going to offer build first to every single resident there, then they should have demanded that the developer develop in phases in such a way that people do not have to move off the site for 10 to 12 years.
Now, there is the plan, as I understand it, does have a one-for-one replacement of the units that are going to be demolished. But I'm curious, there were a couple of exhibits in the materials showing the number of residents currently at Barry Farms, the number of bedrooms that would be required for each family if those units were replaced. And then we see another exhibit of the waiting list in DCHA for those same numbers of units. So I'm wondering, to sort of get a little more detailed picture of some of your concerns, is the concern that families, for example, living now at Barry Farm who are going to be relocated, who need a 3-bedroom unit, would be put on the waiting list for the entire city of residents who are waiting for a 3-bedroom unit through DCHA?
Well, the primary concern right now is that the developer doesn't, well, they haven't disclosed, it's not on the record, how many family units they will be bringing into the property. They've made promises, but
but I thought that is a part of the record. I thought they're going to build 344 units. Is that correct? And then there's 100 that have already been built.
Correct.
Which brings a total to 432. I'm sorry if my numbers are not exactly off, but I thought that the numbers that they're going to build on the footprint in the PUD plus the 100 that have already been built would equal the number that they are tearing down. Is that incorrect?
That is correct. However, the unit allocations has not been set yet. So
meaning 1-bedroom, 2-bedroom,
1-bedroom,
3-bedroom,
2-bedroom, 3-bedroom, 4-bedroom, 5-bedroom. They've said that there will be 1-for-1 replacement, but that is a term of art. It's a legal term of art, and it doesn't necessarily mean that replacement will be on the site. It could be off-site for the 4 or 5 bedrooms.
So that's
and comply with 1-for-1 replacement.
The replacement or the return back once the development is complete is also a part of your concern about the relocation. In other words, we're just trying to clarify the critical points of concern, and it sounds like you're saying that when families are relocated, it's not clear that those families will be able to relocate back to the same size unit that they were relocated from.
Correct, for unit size and other reasons, credit scores, criminal background checks.
I thought the plan says that they're not supposed to re-evaluate family members who live there and who are current and compliant now. In other words, once they leave, they won't, when they come back in a few years, they won't have to go through all of those things you just described again.
Well,
you don't have confidence in that part of the plan.
Well, it's not really a part of the record. My understanding of that situation isn't a part of this record. But yes, we're not confident in that.
How, one of the things that I think that was raised in your motion for reconsideration was that originally the developer was supposed to get assistance from HUD Choice for some of the relocation efforts, and that has not gone forward or has fallen through. I'm not sure how to correctly characterize that. And is that an area of concern that may affect how the relocation works?
It is an area of concern. It is.
Can I just ask, I just want to make sure I understand the full extent of your legal arguments relating to dislocation. Is there any thing other than this FSS 231 that provides a legal basis for your argument that the zoning commission was required to consider dislocation?
That is the basis of our argument, is policy FSS 231.
Okay.
And it's really how you specifically interpret the language, because your interpretation, as we talked about the or versus the and makes a difference in how that policy would be determined.
It does, and also, well, yes.
All right, is there anything else? We'll also give you a few minutes for rebuttal, unless you have anything further that you want to add at this point.
No, thank you.
All right, thank you.
May it please the court, good morning. Let me start where we just were on.
State your name for the
I'm
record,
sorry, Your
please.
Honor, Paul Kiernan on behalf of the applicant. It's also the intervener in this case.
All right.
The applicant, as you know, was District of Columbia Housing Authority, A&R Development, and Preservation of Affordable Housing. Let me start, if I could, on the issue of FSS 2.3.1, because I think that seems to be the nexus of most of the issues here. The policy is to encourage the revitalization of Barry Farm. That is the policy stated, and do so in a manner that ensures one-for-one replacement of any public housing that is removed. That has been done here.
Meaning with the 100 off-site units that have already been built, and then the remaining 344 that are scheduled to be built.
Correct. And on the last point that Your Honor asked a question about, paragraph 147 of the Zoning Commission order reflects the Commission's conclusion that the applicant will ensure that the 344 replacement public housing will meet the housing needs of the current residents.
Meaning same allocation of bedrooms of the units that were demolished.
Of the needs, right, of the current residents. That's paragraph 147.
What do you mean by needs? If I am living in a house right now that has 4 bedrooms, are you saying that the replacement might only be for 2 if I only need 2? Or, so what is one for one mediated by need, or is it actual just replacement of whatever you have?
No, it's the replacement of what you had. Now, again, once people move back in, there may be a reassessment of that, but the...
so I'm not quite sure what you mean by...
Okay, the replacement is for what's there now. So people have a 2-bedroom, there's going to be a 2-bedroom
I
available.
thought the plan was to have nothing larger than 3 bedrooms. Maybe I thought I read that somewhere.
Well, I was referring,
And currently, there are 4 and 5 bedroom units,
there are
correct?
some 4 or 5, and the Commission's finding... I'm sorry? Thank you. The Commission's finding, the Commission credited the testimony that the applicant will ensure that the 344 replacement public housing units will meet the housing needs of the returning residents.
Was that finding supported by substantial evidence in the record? I mean, I read that they credited the testimony, but the testimony was based on an assurance that we'll come up with something, but there's no plan yet. There's no, as I understand it, there's no statement, there's no plan that says we're going to have this many 3-bedroom apartments, this many 4-bedroom units. And given that, how can the Commission make a finding that there's going to be an adequate one-for-one replacement?
Again, this is the first phase of the 2 phases. So this is the overall concept. It is true that not all the buildings have been designed, but the final master plan that was reviewed and discussed in September lays out the assortment of housing options, the variety of both income and type. And that's more than enough at a stage 1 for the Zoning Commission to make this finding that this is going to happen. Now,
Can I ask you,
stage
just
2,
so we understand what it means, or do you interpret that as the Zoning Commission indicating that in future phases it's going to insist that each person who is being given a replacement housing will get the same number of bedrooms that that person currently has?
I'm sorry, Your Honor.
I'm just trying to figure out what you think the Commission meant, what you understand the Commission to have meant when it said housing needs will be met, and what that means about one-for-one replacement. So my question is, do you understand the Zoning Commission to have found that, at least for now, it has sufficient reason to believe that when this is all done, each person who has N bedrooms in their current living accommodations will be given access to an accommodation that has the same number of bedrooms?
Yes, that's how I understand what they have reviewed and approved. Now, the final design has not been finalized yet.
Doesn't
But
that go to the concerns raised by the Tenants Association about the relocation? You know, it might cause some hesitation to leave if you have a 6-bedroom unit and you don't know if you come back you'll get the same unit.
But the issue, Your Honor, I think is maybe the difference between the dislocation and the relocation. The policy talks about dislocation, and I read that to mean that people are being forced out of the neighborhood with no chance of coming back, and they're creating that kind of hardship, as opposed to relocation, which is necessary to complete the policy of encouraging the revitalization of Barry Farm. I mean, in none of the plans, in none of the new community initiative, the small area plan, the Comm plan, in none of those is there a policy in favor of leaving everything the way it is. That's not the plan. This is a neighborhood enhancement area.
Right. So with the relocation, one of the arguments raised by the appellants is that the commission should do more to give oversight to the relocation plan, or to make sure the relocation plan actually has some teeth. And the commission ultimately decided that they didn't have jurisdiction to do that. Who does?
I think there's two phases. I think there's a zoning aspect to reviewing the relocation plan, and I think the zoning commission did exactly that, which is, are we satisfied that the revitalization is being done in a manner which ensures that there are measures to assist residents and avoid dislocation or personal hardship? That's different than saying that the zoning commission should manage the relocation process. So what the zoning commission did, I think, correctly in implementing this policy.
Well, what's going to happen down the road? Because as I understand it, the next phases, with each of the next phases, DCHA is required to submit more detailed plans relating to relocation. So if the zoning commission must have some reason for requiring the submission of those plans, what's going to happen with them?
But that's in the second stage, Your Honor. So
Right,
the
so
first,
what is the zoning commission going to do with those plans? And is that before, and whatever that is, does it occur before or after the current units are demolished?
no, the second stage PUD application, the second phase of this, will require detailed drawings of what exactly is being built where, with whatever additional relief may be needed regarding height or density or setbacks or whatever. And along with that, the commission has ordered a detailed relocation plan be submitted for the entire project. And then at each other second stage application for each phase of this, a progress report or status report about how it's going. That, it seems to me, is the zoning aspect of what the commission is doing, should be doing, to satisfy this policy of ensuring that measures are being taken to assist.
But when in the sequence of events is the current housing demolished and the current residents, when are they moved out?
Well, as was alluded to earlier, some of the residents have already moved, but of these 344, the new project has to be approved at the next stage. We're only at the first stage. So each of these buildings, as they are proposed to come online, have to again be approved. So there will be another bite at the apple, as you will.
Well, that's what I'm trying to understand.
To look at that.
I'm trying to understand whether the BFTAA is going to be able to be heard on these more detailed plans in front of the zoning commission, and if necessary in front of this court, before they're actually displaced.
I believe so, and that's the point of the second phase of this, and I think the commission's requirement a detailed plan be submitted at the very first of those applications to make sure that up front it is satisfied that the relocation plan is being, that there is one, that there's a return plan, and how this is all going to happen. So I think the opponents of the project have another chance to review exactly what that plan is going to be, and if they feel appropriate, to object to it and to raise it with the zoning commission.
So I understand your point that there are aspects of the commission's order that gets into the question of the adequacy of the plan to address dislocation, to deal with relocation, if you're distinguishing between those two concepts. But there is a part of the Commission's order that seems pretty sweeping in its language, that's in the area of around paragraph 150 of the order, where the Commission says, the Commission finds that the issues addressed below are not governed by the zoning regulations or are otherwise beyond the scope of the testimony and evidence of record in this case. And then the next paragraphs are relocation and return plans. That sweeping language seems, it's unclear to me that sweeping language is correct.
I think, Your Honor, as I read that, it is that the objectors raised that the zoning commission should apply the URA, and that's how I read the language. The commission says, we're not charged, the URA does not confer jurisdiction on us to decide relocation plans. We're not, in fact, a relocating agency.
Well, but I mean, the wording in 152 is, the Commission finds that the relocation process is outside of the Commission's jurisdiction. I understand, I guess you read that as meaning, what, that the Commission can't assess the legality of the plan relative to the federal statute?
Yeah, the objection was that the federal statute, the Commission said the federal statute is not for us. They didn't say this isn't for us, the FSS, and they specifically go on to find that. Moreover, I would point out, Your Honor, an earlier panel of this court specifically looked at this issue on summary affirmance. I know they vacated the summary affirmance issue and allowed the additional briefing, but in its order of April 22nd, it specifically referenced this issue, and said, contrary to petitioner's assertion, respondent did consider whether DCHA's relocation plan was consistent with FSS 2.3.1.
Well, I don't disagree that there is ultimately consideration. I'm just a little unsure of what the Commission meant and how to interpret the Commission's. So the Commission says two things. First, not our job. Second, we're going to do it anyway. And you're interpreting the first of those somewhat narrowly and saying what the Commission was saying wasn't its job, was really getting into the weeds of the federal statute and maybe getting into the mechanics of managing things.
Correct.
And I mean, I understand that position. It's just not so clear to me that that's what the Commission meant, because the Commission's language seems not so precise and instead a lot broader.
But I think in context, Your Honor, where they then go on in 153 and say that they're making a finding that's not inconsistent with FSS 2.3.1, they are doing the zoning piece of it. They are saying we are not the URA agency. We shouldn't be getting into the weeds, as it were, on this issue about how to do the relocation. But on the zoning issue, which is encouraging revitalization in a manner to assist residents and avoid dislocation, they say we do find that the relocation plan is not inconsistent with that policy goal. I think that's how you reconcile that.
Can I ask you about the debate there appears to have been in the briefs about how to interpret FSS 2.31 and its use of the disjunctive or as between in the sentence avoid dislocation or personal hardship. If I understand your brief, so I just want to see if I am understanding it correctly, your view is that what that means is the Commission could pick either one of those and try to avoid it and ignore the other? Am I understanding your brief correctly?
I mean, it does say or avoid dislocation or personal hardship.
So you think the Commission could have looked at this and said, I mean, it wouldn't have been feasible here, but a Commission looking at that language could have said, well, no one's going to be dislocated at all. It's true that there's going to be horrendous personal hardship, and we're taking no steps to deal with it, but we were allowed to just pick one or the other and advance that interest or protect that interest without regard to the other?
I don't think that's really it in the way that this is written, Your Honor, because it's along with measures to assist residents and avoid dislocation or personal hardship. I think the or goes with to assist residents and avoid dislocation or personal hardship.
I'm not sure I follow the grammar of that.
Okay, so
could you say, I'm not sure I understood what you're saying.
The phrase is ensure one-for-one replacement along with measures that, again, encourage the revitalization in a manner which ensures one-for-one replacement, along with measures, and I implicitly read that adopting measures or insisting on measures, to assist residents and avoid dislocation or personal hardship. And
It seems
It
like-
sounds like if you're saying the or goes to assist residents, then it sounds like you are interpreting the language the same way that the appellant is interpreting it. That to assist the residents by avoiding hardship and dislocation.
to assist the residents and avoid dislocation or personal hardship. I guess I'm not, I don't think it's I think it's or. I think it says or.
Well, it's definitely or, but there are plenty of cases that say sometimes in context or has to be understood as and. And so if, somebody, if I'm lending, my car to my child and I say, don't drive fast or drive drunk. I mean, it's true I said or there, but if my child said, oh, well, I was free to pick one, so I didn't drive drunk, but I drove really fast, and that's fine, everyone would understand that or means and this seems to me to be a very similar construction.
But I read it, I take your point, but the personal hardship is not the same as dislocation. There may be dislocation that's personal hardship. There may be personal hardships that are not dislocation.
That's certainly true, but I'm not sure that addresses the question of whether this or really is understood as meaning and. When you say avoid A or B, oftentimes that means in context avoid, you're trying to avoid both of them. And so or is often used in formulations like that and understood to mean and I'm just wondering whether this is a case that's like that.
Because I don't think the policy equates dislocation and personal hardship to me the same.
Well, they don't have to be the same. I mean, driving fast and driving drunk are not the same. But if you say avoid one or the other, sometimes in context it clearly means or, but in settings, in context like this, it seems a little implausible that the commission would have, that the council, I guess, which enacted this into law, would have meant to the commission, pick one of these things, and you can, protect one, but feel free to ignore the other and pick whichever one you like. You could let everybody be dislocated as long as they have no personal hardship, or you could let everybody have tons of personal hardship as long as they're not dislocated.
I guess, Your Honor, I can't see a construction of that goes with the opening phrase about assisting residents. To assist residents and avoid dislocation or personal hardship. It's hard to see how you'd have something in your.
Well, I'm not sure that I'm not sure anything further in the sentence modifies assist residents.
Let me ask you a question. If one were to assume that FSS 2.3.1 did require the commission to insist that dislocation was avoided, do you agree with the BFTAA's argument that would require a build first approach?
No.
Why not?
Because, the build first, as was discussed earlier, is the term, if you're using the term within the New Communities Initiative, refers to it's in paragraph 59 of the Zoning Commission's order, I think, refers to a specific process of creating housing in the area, I think it's 59, in the area for people ahead of, 59, constructing units off-site and in the community to provide housing in their base community during redevelopment. I don't think that is dislocation.
All right, maybe I misunderstood what the argument was. I mean, as I understand what the BFTAA's argument is that to avoid dislocation, the developer here should be required to build some of the new housing of this PUD first, so that the people who are being moved out of the existing housing can have a place in their own community to live while the construction is ongoing. Is that?
That's not what I understand their argument is, but I understood their argument, this build first concept under the NCI.
Do you view the giving of the feature of the plan that has 100 or so of the replacement units being off of the Berry Farm site, do you view that as dislocation?
No.
Because in your view, dislocation means removal from the community, and the community is defined more broadly than the Berry Farm site?
Right, correct. Dislocation meaning I don't have any place to go in my community. Again, to make the point which I believe Your Honor made earlier, if this area is going to be revitalized, the buildings are either going to be rebuilt in place, which is not what's approved, or they're going to have to be taken down and replaced with something. And in the meantime, the residents are going to have some place to live. That's not dislocation. It may be relocation, it may be temporary relocation. That's different than dislocation. Or
What-
displacement was the word in the brief as well. They're not being displaced.
You talked about the purpose of the plan being to revitalize the community. One of the arguments of the BFTAA is that the commission didn't properly consider the amenities that already exist in the community. The fact that there's a lot more open space, yards, courtyard areas, parks, that would be, that should have been weighed and considered against the potential and proposed new amenities, and that wasn't done. How do you respond to that, and do you feel that there was sufficient evidence in the record substantial evidence in the record for the commission to conclude that the amenities that the development is supposed to provide would outweigh any other concerns?
I do believe there was more than enough evidence on open space, transportation, housing stock.
Well, but is there going to be less open space now with the higher profile, higher rise buildings and the increased number of units? Or is there going to be more open space?
There's going to be, bear with me 1 minute. My co-counsel says on a percentage basis, we believe it's about the same amount of open space. It's configured differently, that's for sure. But on a percentage basis of the overall site, it's about the same percentage of open space.
One of the arguments that's made in this court is that the commission, similarly to the question Judge Blackburn-Rigsby was asking, that the commission didn't really adequately weigh what you could also view as adverse impacts. Here, the argument is the current situation in Berry Farm, housing may be in need of restoration. There are various problems. But there are benefits too, is the argument, that people have their own yards, and there's a list of various kinds of benefits. And the argument is that that the loss of that is an adverse impact, that instead the situation is going to be that there's going to be more like a high-rise apartment structure that won't be the same. And that the commission, it might be at the end of the day that the commission could say, well, it's true, we're going to lose that, but on balance, we're getting a lot of things that make that worthwhile. But that the commission didn't go through that exercise, that you can't find in the commission's order an acknowledgement that there are things that are going to be lost and a weighing of the pros and cons. Is there a part of the commission's order, well, let me be more general. What do you think is wrong with that argument?
I don't disagree with the premise. In other words, the zoning commission doesn't do what you just said, Your Honor. But I think there's several things. First of all, as I said earlier, every planning policy, the comp plan, the small area plan, the new communities initiative, the input from all the agencies, everybody on that front thinks that the current situation needs to be changed. And I understand the argument that it is the way it is now and shouldn't be changed, but that's not the direction that the comp plan points to.
I don't think that's quite I think the argument in its narrower form is less that and more if it is going to be changed, and the commission needs to acknowledge what will be lost in the change and to have gone through the process of saying, all right, we understand that's going to be lost, but it's outweighed by what will be gained. And that's in some ways more of a process point or about the adequacy of the commission's explanation as opposed to just a view that the commission couldn't lawfully change things.
Well, they did make some findings about the existing, for example, the existing street grid in the area, that this is what's wrong with it. They did talk about the access to the streets and to the metro. They did talk about the availability of varieties of housing in there. So I obviously agree with you, they didn't do the analysis that you just did, but it's not like they didn't pay attention to what was there and why they were suggesting it be changed. I don't think it's an issue that they are required to say, here's where we are and here's where we should be, and we should acknowledge what we're losing. I don't think they need to do that under the law.
That I'm puzzled by. I mean, the commission's job in approving a PUD is to, among other things, weigh the adverse impacts. You agree with that?
That's right.
That's by
That's
regulation. Right. And if there is a good feature of an area and the development will cause the elimination of that good feature, how could it not be an adverse impact that the commission has to consider in weighing the pros and cons of whether development, the PUD on balance is warranted?
Well, I'm not sure I agree that they didn't consider it. I agree with you that they didn't write about it. I agree with that.
What in your view, do the commission's rules require them to weigh? Are you saying that under the commission's rules and under the law that they don't have to weigh the existing benefits of an area to be developed as compared to the future benefits? Is there another test that they are required to apply?
Well, they're supposed to look at the benefits and amenities that are to be created by the PUD under the regulations, and they go through that in some detail in their order.
And that,
around paragraph
by the regulations, you mean which regulations?
The PUD regulations. Section 2400.
2400, 2403,
3,
9, 10, 11, and 12.
9. And Judge McLeese's question was 2403.8, I think, which is the commission shall judge, balance, and reconcile the relative value of the project amenities and public benefits offered, the degree of development incentives requested, and any potential adverse effects according to the specific circumstances, which I think is the section Your Honor's talking about.
Can I ask you, I don't know, we've touched on it yet, but a component of your opponent's argument is also to object about the considered in isolation relatively high-density structures that are on one portion of the planned development. And they argue that the commission, although the commission did talk about the need for that and having to, that was justified because if you wanted to be able to finance, creating all these new structures and everything else, that was necessary. But they argue that the commission didn't really adequately explain the basis for its conclusion that that was financially necessary, and I think relatedly they argue that there wasn't, in fact, put in front of the commission sufficiently detailed information on that topic. And so I'm wondering what your response is to that objection.
I think there was both, the evidence and the discussion. The evidence submitted by the applicant regarding the cost not only of replacing the housing and providing the additional affordable housing far above what would normally be required, but also the infrastructure costs and the other costs. And the commission used the language in paragraph, excuse me one second.
Where in the joint, is there a place in the joint appendix or in the record where you think that we would find kind of detail? There's definitely numbers about cost, but sort of here is why it needs to be high density and you need to get to 1,400 rather than 1,100, which was the number that had been used in the small area plan. If one were looking for the detail, like showing your work on that, where would you point me?
I think the September submission, Joint Appendix 236 to 241, and there's supporting documents behind that. And the commission's findings of fact 112 and 113 about leveraging to allow with the successful development of not only the public housing, but the affordable housing units. And they talk about the infrastructure costs, the public housing costs, and the costs in excess of the low income. And then in paragraph 128, I believe it is, Your Honor, they talk about specifically the higher number of units. I think you asked about that.
Right, and there's no question that unlike in some prior orders, the commission did address the topic. But I think you would acknowledge that certainly the commission didn't show its work in detail in the sense of saying there's a dispute here about whether 1,400 is needed or whether the objectives could all be achieved with a development that had only 1,100 units. And here is, we're siding with the developer on that, and here's why. And here's the underlying basis. That's not so much in the commission's
That's
order.
not so much in the order, but again, as I know you know, that this was an iterative process. There was a higher number, there was some back and forth with the ANC, there were discussions, there were modifications, there were reductions. We've got the final order, but obviously there's years of hearings and proposals and suggestions and movements behind all that. And so, it's not a take it or leave it. This is the result of a process that the Barry Farm Resident Council, the ANC, and the city, and everybody were working on to get there. Can I just have 1 second, Your Honor?
Sure. How long is the, I'm sorry, did you want to respond?
I just wanted to clarify one thing on Your Honor's open space question. I believe it's about the same, but we can get back to the court to confirm.
My question about the open
percentage
space.
of open space before
Okay.
and after.
How long is the redevelopment project estimated to take once it begins? In other words, how long would families be relocated?
Well, it's obviously a multi-year process from beginning to end. I don't know what the current estimate is. Obviously, it depends on when things get started and financed, but it is a multi-year process for sure. For sure. And on that point, Your Honor, if I could just finish up on this, we appreciate that the court put this case on an expedited briefing schedule. And we appreciate your expedited consideration of it because we do have a project and the neighborhood has been waiting a long time on this. And so we appreciate you putting this on an expedited schedule.
All right,
Thank
is there anything further? All right, thank you, Mr. Kiernan. Mr. Theresa?
Yes.
Well, first, we'd like to say that we don't think that there will be another bite at the apple. They've already put in a request to demolish with HUD. So
You mean another bite at the apple to
In
have the
terms of-
commission look at the relocation?
and us be able to argue against it while people are still living there. They've already started moving people out of the residents at Berry Farm through various means, but the number of people dwindles as we go on. Also, it is our argument that unless you build first for every resident, it constitutes dislocation and hardship because you're splitting a community apart. If you build first for 100 families and then send 300 families to the wind or 200 families to the wind.
Let me ask a question about something related to this point. You mentioned in your original portion of your argument about your expert witness who you felt didn't have a fair opportunity to testify, who was qualified as an expert in history as opposed to being qualified as an expert in gentrification.
Yes.
But I thought that the expert ultimately did testify.
They did testify, but they weren't given
On some of the issues that you're talking about, like splitting up the community and splitting up
Correct.
neighborhoods.
But it wasn't given the proper weight as an expert versus just someone testifying.
Can you clarify for us what you meant in your first argument as to build first, or what you think that the FSS 2.3.1 would require the zoning commission to require?
Yes, we believe that FSS 2.31 or 231 would require them to build first for every resident in the area, and that way it could be fulfilled.
What do you mean in the area?
In the immediate vicinity, so people don't have to switch schools or switch their whole entire life around, basically. I mean, it's not a science, but just in that area, in that Anacostia area, the Sheridan Station would be perfect because it is right down the street. But you can't just offer it to a fraction of the residents. It has to be for everyone.
So make sure I understand, you have no complaint about the 100, you agree, I'm asking, do you agree that the 100 build first type units are adequately in the neighborhood to avoid dislocation? And your objection is not so much with those, but rather that there should have been 430 of those rather than 100?
Right, yes. And also, it is not the same amount of green space. I don't have the exact numbers. I mean, I've looked at the plans and I'm very familiar with the landscape over there. We'd be happy to get with you with some numbers as well, if we could put them together, provide them to the court.
I don't know if this goes directly to your argument. Your concerns are not with the development plan for revitalizing that area with new housing of different kinds and some retail and roads. Your concern is in the interim while the development is going on, what happens to the residents in the community?
Correct. And also the density and all of that stuff is also part of our argument that going from 1,100 to 1,400 units and how the site will be when people come back is also part of our concern.
I have a question that may not be aimed directly at any of the legal issues before us now, but just trying to understand the dynamics here. There's been some reference to the Berry Farm Resident Council, and then there's your organization. Can you just kind of help us understand who's part of each of those entities and what the differences are?
The Berry Farm Residents Council is an entity formed by the DC Housing Authority. There's some question as to whether or not they represent the interests, the true interests of all residents. They've gone on retreats with the DC Housing Authority, and colloquially, they receive benefits that other residents don't. People who are a member of the Residents Council, members of the Residents Council actual board, and so there's some question as whether or not they have incentives to act on behalf of residents instead of just kind of falling in line with what DC Housing Authority wants. And Berry Farm Tenants and Allies Association is made up of residents of Berry Farm who are opposed to the development and its current iteration and how it's been offered. So that would be the difference.
The applicant's brief, I think, suggests that your organization doesn't have really all that many actual residents as part of it. Is that accurate, inaccurate?
I know we have over 100 signatures against the development as it's been proposed.
Signatures of residents?
I believe so, yes. And also, I'd like to respond to one point that he made about the ANC. In the order, the commission recognizes that the ANC order that approved the project was not done lawfully. There was not proper notice given, and so really the ANC commission order that should apply is the one that denied this project and said that they wanted XYZ terms fulfilled. However, the zoning commission, they held that since the things that ANC wanted are outside of its purview, that it didn't matter, that they were just going to go with the new ANC order, which didn't have proper notice.
All right. And it's the new order that agreed to the
It's the
1,400 units.
Right, exactly. Mm-hmm.
All right, there's nothing else. Thank you, both counsel, for your arguments and your briefs, and the case will be taken under advisement. And at this time, we stand adjourned. Thank you.
All rise.